This morning, we're looking at the activities and the results of the Nigerian Presidential Polls Dispute Claim, of course, the PEPC, that did affirm President Bola Tinubu yesterday at the court. This morning, we're joined by Magaji Mato Ibrahim. He's a senior advocate of Nigeria. He'll be joining us to explore the conversations from yesterday. Thank you so much for joining us this morning, sir. Hello. SAN, are you with us? Good morning.
Thank you for having me.
Yes, thank you very much for joining us. I think before we get into
Thank you very much, and thank you for having me.
All right, thank you. Now, before we get into the question or the meat of yesterday's conversation, let's ask if you foresaw, the way in which the judgment was delivered. Did you foresee that it was going to be in line with our Lord's position, or did you think that there was going to be a deviation from what was for the judgment that was reached, especially as regards the presidential election? All right, I don't know if you can hear us. I was asking if you did expect that the judgment will lean in favor of the way that the judgment went, or were there any surprises for you yesterday at the court?
I think
all right, we are trying to establish connection with our guest, Magaji Mato Ibrahim, who's a senior advocate of Nigeria. But just to quickly reiterate some of the points that were reached, some of the conclusions that were reached at the court yesterday, the court did reach, as regards the 25% requirement, that the FCT is not more special than other states. That is what the court did reach. A number of the Labour Party, I think 10 out of 13 of the Labour Party witnesses were rejected by the court. We also did find that the electronic transmission of results optional court rules that we could not pressure INEC to transmit results, to do a transmission of results. The tribunal also dismissed the EU's report on 2023 elections that was tendered by Obi and the Labour Party. We know that the EU did share their reports on the elections, and they were quite, they weren't the best review of what happened, and the court rejected that as an evidence. Tribunal dismissed Obi and Labour Party's petition on election irregularities. Part of what the court did say was that they were not able to establish the numbers to give the figures as to where exactly, give exact figures as to where things went, where the election was being manipulated in terms of the numbers. Labour Party and Obi didn't prove Tinubu's conviction in US, according to the tribunal. That was part of the ruling of the tribunal. And great news for Natasha Akpoti Uduaghan. The tribunal nullified APC's victory and declared her the winner. We'll be joined again. We'll try to reestablish connection with our guest, Magaji Mato Ibrahim, who is a learned SAN. He will be joining us to explore the conversation from the judgment and the rulings yesterday. Good morning, and thank you very much for joining us, sir.
good morning.
All right. I would like to get into the conversation yesterday. I think before we get into the meat of what our Lords reached as per the judgment, let's talk about your thoughts. Did you have any surprises as regards the judgments from yesterday? Or did you expect that everything will lean in favor of the way that my Lord announced, whilst reading the judgment?
Well, thank you so much for giving me this opportunity to speak to News Channel TV and then by extension to Nigeria and the general public. This judgment did not come to me as a surprise because, beyond the surface, when it comes to issue of litigation and the justice system, there are so many issues that are being looked upon, some in the line of law and then some in the line of technicality. Now, the justice that is to be done by a tribunal or a court of law must be that is looked upon based on the provisions of the law. I mean, when I say law, I mean the relevant laws governing the elections in this country. So there may be differences in our perceptions and in the public perceptions about what the outcome of the judgment should be. But if you listen to the judgment that was read yesterday very well, devoid of any sentiment and any position that must have been taken by anybody, you will have no doubt in believing that there was an X-ray of all the evidences laid down by the petitioners and the respondents in the appeal, in the tribunal. And you could see that evaluation of those evidences were done, and then the law applied. So based on the judgment that was read and based on the evidence that were presented by both parties or both sides, I had no doubt and I had no surprise that the judgment turned out to be in the manner in which it was given. We may have our own opinions, we may have our own perceptions, but that doesn't change what the law has provided. And I think the learned justices of the tribunal, the Presidential Election Tribunal, have done their bit. And in their understanding, they have presented what they feel is the position of the law, married to the evidences of the parties. And I think it didn't come to me as a surprise because evaluation was done in the way and manner it should have been done. And then their understanding might not really capture the popular view of Nigerians, but by and large, they have delivered the judgment, and that is the outcome of the judgment as well.
Yeah, you say their understanding may not capture the popular views. I think I heard a couple of days ago people questioning, why, such a decision will be left in the hands of, just a handful of people. But I want to, ask further on one of the things that was spoken about, one of the parts of their rulings, and that is with regards INEC's declaration, or the court rather, the tribunal declaring that, the uploading of results was left, as a decision of INEC, and there was no laid down rules. It didn't matter. I mean, the tribunal almost is saying that it doesn't matter, whether results were uploaded or not uploaded. So can you share your thoughts on, that ruling in particular? Because I remember that in the build-up to the elections, INEC made mention, and it was part of their rulings, part of their directives, that results must be uploaded, of course, on the INEC server. So, when did that change? And how did the tribunal decide to disregard that aspect?
Okay, we need to understand two things here. There is what we call moral understanding and then the legal understanding.
Yeah.
From the law as provided by the Electoral Act 2022, you have heard the tribunal made reference severally to Section 134, Sub 2 of the Electoral Act. And you could see, and so many other sections of the law, of the Electoral Act, the position taken by the tribunal is born out of the provisions of the Electoral Act. The Electoral Act, which is the law governing elections in Nigeria, specifically stated, did not make a specific provision that transmission of results from the polling unit must be done electronically. Now, but INEC, in the bid to show commitment to Nigerians, made a rule. And that rule was not a rule of, or it was not an act of the National Assembly. It is an in-house rule. Even though in truth and on the basis of morality, INEC was bound by the rules it has made itself to present to the public that, look, in the conduct of this election, based on the Electoral Act, and by the powers conferred on all by the Electoral Act, this is the way and manner we intend to conduct these elections, so that there will be transparency and the general public will believe that we have nothing to hide from them. So because of that, we have made a rule by ourselves that we intend to transmit results electronically from all polling units across the nation. Now, this rule is binding on INEC as far as INEC activities are concerned in the conduct of the general election. But here we are in a situation where INEC, for one reason or the other, as they said, rightly or wrongly, could not live up to expectation or up to the promises they have made to Nigerians. But then the matter comes to court. and the issue was raised. Look, the petitioner's position was that the tribunal should look at it. INEC made a promise that on the day of elections, they would transmit results electronically. But because they had an ulterior motive and they something to hide from the general public, they decided that only at the presidential elections that their machines got faulty. So on that ground, we are asking you to nullify this election because INEC failed in its promise. So we have to look at it from two perspectives. There is what we call social contract and then binding contract. Now, social contract is a promise you make that is not binding on you. For instance, if I tell you, look, next week I'm going to take you to London. And it stops there. Because you are my friend, I'm going to take you to London next week. And come next week, you were waiting for me to say, okay, see your flight ticket and see your accommodation, ticket for accommodation. And I failed to do that. The question is, do you have the locus or the right to take me to court on that basis? The answer is no. But the respondent said, no. The only law that governs elections in Nigeria is the Electoral Act. And the Electoral Act has not said that INEC is under any mandate to transmit results electronically. So having not done so, they are
what you're saying
failed in a promise which they made to Nigerians, not that they have failed in the law.
Yeah. So what you're saying, and I apologize for jumping in.
But by the time you look at the electoral, the INEC guidelines and regulations, yes, that provision is there. But the question now is it binding on law? Is it something that has the backing of law? There are rules that were made by them. You know, any law that must be binding on Nigerians and on the court must be that law that has been made by the National Assembly or the State Houses of Assembly, as the case may be. So this is the situation that we got ourselves in, unless and until the National Assembly incorporates the INEC rules and regulations, and the INEC regulations and guidelines to become substantive parts of our law or of the Electoral Act, we will still have challenges in the application of those regulations. Because if the substantive law says, no, you are not under compulsion to do it, and you on your own, in the bid to show transparency, you decided to say, okay, I am making rule for myself now. Not that the law is made against on you, but you are making the law or the rule for yourself, regulations to guide our conduct in the way and manner we're going to conduct this election, so that Nigerians will believe that we intend to give them the best of elections. And you later fail, you are only bound by your conscience, not by law.
Yeah,
so that is the position.
So what you're simply saying, and I'm going to let Olive jump in next, is that, the Electoral Act can say one thing, which is that, of course, it is left for INEC to decide how they will transmit results or how they will conduct the elections. And then INEC can decide to change its mind at any point, halfway through the electoral process. They can decide that, voting will be done, with, the IRF, with, BVAS. And then at any point, for any reason, they can just randomly decide, that they are no longer doing that. And everybody has to fall in line, regardless of how it affects the outcome of the elections, which, I don't know how, we're going to accept that as a standard, for running elections. But there's other angles and there's other things that were mentioned. I'm going to let Olive go on.
All right. I want to move away from there and head over to the 25% in the FCT conversation that has sparked controversy in the past couple of months. And I'm just going to read out the constitutional provision. I think Section 134, subsection 2 of the 1999 Constitution states that a candidate for an election to the office of president shall be deemed to have been duly elected, where there being more than two candidates for the election, he has the highest number of votes cast at the election, and he has not less than 1/4 of the votes cast at the election, each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. Now, from what we've seen, the Supreme Court has reached the requirements, reached the judgment that the FCT is not more special than other states, and the 25% count or 25% argument doesn't hold water, regardless of whether or not Mr. President won the elections in the FCT. Now, the question is, I'd like to find out your thoughts on the court's analysis of that particular, or the court's interpretation of that section of the Constitution. Is it a bit too convenient that the FCT doesn't count as a state during other situations, but only when it comes to elections? Is it maybe time, the residents of the FCT have started to ask that maybe it is time for them to conduct elections, to ask for elections that would then produce their own governor, and then they should be treated as a state, because prior to the elections, it is the FCT. It's not really been counted as a state, but now it is now counted as a state based off this interpretation of interpretation by the judges. So, do you think that the judges were being fair, or do you agree with the interpretation of Section 134, subsection 2 of the Constitution? And also, do you think that maybe it's time for the residents of the FCT to start to demand for their own gubernatorial elections and maybe their own governor?
Yeah, but so that I will not sound contradictory, I would want to take you back to some few months, I think some few weeks before the election. I think I was in this channel, and then this same question was put to me, and my position has still not changed. And incidentally, it also became the position of the Tribunal, the Presidential Tribunal. I have said this before, and I think at the risk of repetition, I will still say it. You see, the law is there, and the Constitution has made that provision. But we are talking about interpretation, and there are rules of interpretation in our judicial system. Right from the beginning, even before this present election, I'm not speaking for any party, but the position of the law is what I stand to defend as a lawyer. The interpretation is not just now. Even when you heard them talking about the 25% of the FCT does not make any difference with any other state, it has been long interpreted by the Supreme Court. You heard the Tribunal also relying on a decision earlier made by the apex court of this land. So now, what we are saying is, or what the law is saying, is that 25% and FCT. Now, FCT has always been seen as the center of Nigeria. But for the sake of elections, the proper interpretation that has been given by the court still remains more logical than any other interpretation that you can give. If you say you must have 25% of all the states in an FCT. Now, the point is, if you look at it from the point of logic, even keep the law aside, what is special about the FCT? Are there no same Nigerians that are in other states that are in FCT? So what is it that you say somebody who has gotten all the requirements as constitutionally provided, now simply because he has failed FCT, you now disqualify that individual? So the Supreme Court, even before now, has given the interpretation to mean, as far as election is concerned in Nigeria, there is nothing different about FCT with other states. Once you are counting 36 states, the next state that comes is FCT as far as election is concerned. Because logically, if you now say, oh, you have won all the states in Nigeria, but because you don't have FCT, then that means you have lost the election. It's logically not going to be fitting. And I think the earlier we understand this in the better. As painful as it may be to the petitioners, I think that has been the position of the law. And I'm just even surprised that that became an issue here. But I think it's good we always test the law. And I am happy that maybe some of the petitioners will definitely go up. We'll still hear what the position of the Supreme Court will be on it. But I know that it's not a new issue. FCT has always been seen as the center of Nigeria. But for the sake of elections, the proper interpretation that has been given by the court still remains more logical than any other interpretation that you can give. If you say you must have 25% of all the states in an FCT. Now, the point is, if you look at it from the point of logic, even keep the law aside, what is special about the FCT? Are there no same Nigerians that are in other states that are in FCT? So what is it that you say somebody who has gotten all the requirements as constitutionally provided, Now, simply because he has failed FCT, you now disqualify that individual. So the Supreme Court, even before now, has given the interpretation to mean, as far as election is concerned in Nigeria, there is nothing different about FCT with other states. Once you are counting 36 states, the next state that comes is FCT as far as election is concerned. Because logically, if you now say, oh, you have won all the states in Nigeria, but because you don't have FCT, then that means you have lost the election. It's logically not going to be fitting. And I think the earlier we understand this in the better. As painful as it may be to the petitioners, I think that has been the position of the law. And I'm just even surprised that that became an issue here. But I think it's good we always test the law. And I am happy that maybe some of the petitioners will definitely go up. We'll still hear what the position of the Supreme Court will be on it. But I know that it's not a new issue in our jurisprudence, legal jurisprudence. It has been long interpreted to mean the FCT does not make any difference with other states as far as the electoral system of Nigeria is concerned. And that is the position. Now, I just want to make a comment to what my brother there has alluded, that because of that, INEC can just at any time decide to just change the rules of the game in the middle of the game at their own whims and caprices. No, that is not what I had in mind to say, and that was not exactly what I said. I said the law is different from the rules, in-house rules. Now, you may just take a practical example. If I am living in a state and in that state, there is a law that says you must not go out once it is 12 o'clock. That law binds not only me and my family, it binds the entire citizens or indigents or dwellers of that particular state. So that law, I don't have the right to change it because I am not the one that made it. And I don't have right to deviate from it. Deviation from it means that I'm incurring for myself punishment. But if I make law in my family as a husband or as the father of the house, and I say, okay, every day we are going to eat chicken, and for one reason or the other, maybe my salary has been withheld by my employer, I've not been paid the salary for that week, and unfortunately, I'm not able to make do that my promise of eating chicken every day in my family. I don't think my wife or my children will sue me to court to say, oh, it's by right, since you promise us chicken every morning or every day of the week. Now that you have not been able to provide the chicken, we'll take you to court so that the court will enforce that our right on you. You have to get it from this point of view. Otherwise, we'll be mixing the point. If the Electoral Act has provided a way and manner of doing things on INEC, and INEC failed to comply with that way and manner of doing it as provided by the Electoral Act, which is made or was made by the National Assembly, I assure you no court of law in Nigeria or anywhere else will interpret it otherwise. But if INEC on its own decided to say, oh, we are happy we are INEC, we are happy we have been saddled with responsibility to conduct elections in Nigeria, and to show you how happy we are and how sincere we intend to be, in fact, we will not only transmit the result manually, but we are going to also transmit it electronically so that from the point of elections, everybody in Nigeria gets to know what the result is from each polling unit. But they are unable to make do that promise they made to Nigerians, which is not law, it's their regulations and guidelines made by themselves as empowered by the law. Now they are unable to do it the way they promise us. We cannot, and the court of law, because the court is sitting to interpret the law.
Okay.
What somebody has made a promise to do morally. I agree. Morally, INEC is wrong. And this can only be a challenge, not only to us, but to our legislators. So that we know that electronic transmission is one of the ways to avert or to stop electoral malpractice. Can you please make do by including and introducing, making it mandatory that INEC must transmit result electronically in the Electoral Act. Once that is done, I assure you, any change in this manner of doing it will incur a sanction by a court of law.
All right. Unfortunately, we may not have time to continue to expand We may not have time to continue to expand on these things because, I was also going to share, from the guidelines that INEC gave to polling agents, how they, of course, would carry out the elections. There's also the parts where the vice president was accused of having double nomination. The tribunal apparently said he didn't do it knowingly. And of course, the question really is, if the tribunal, seemed to, or, that it was set up to look out for technicalities with which to dismiss these cases or actually look through the cases on their merits. But unfortunately, we're out of time. We will be speaking with you again as things unfold. Thank you very much, Ibrahim Magaji, for, of course, joining us this morning, and, of course, SAN, I beg your pardon, for your time. We look forward to speaking with you again.
Thank you very much, and I sincerely appreciate it.
All right.